Item 1 WPC 997/10.
Read petition dismissed.
Item 2, 3, and 4 for judgment.
So all three read petitions have been allowed. Their services not to be terminated.
Lords. Obliged.
Financially.
May it please your lordship. Item number 53, my lord.
Yes.
In view of an order passed by the authorities for demolition of the building of the respondents, nothing survives. So I may be allowed to withdraw the writ petition with the liberty.
If nothing survives, where is the question of liberty?
Things,
It's become infectious.
things spring up, my lord.
No,
The liberty will grant.
infectious.
I have filed an impleadment application in this matter.
That goes. Mr. S. Bonig, learned counsel for the writ petitioner in item 53 submits that the authorities have already issued an order for demolition of the
By
building
order dated 38/2023.
on 38/2023, and therefore nothing survives for decision in this writ petition. In view of the above, no, you're right. Taking note of the submit, you write, Mr.
M.H.
M. A. Chaudhary, learned counsel is present on behalf of the.
He has not yet been.
Impleaded manner, we filed an impleadment application.
All right. Then taking note of the submission of Mr. Bonig, this writ petition stands disposed of as infructuous. Full stop. Then you write, there is a IA. What is the IA number? 1586 of 2000, Mr. So-and-so appears for the applicant. Since the writ petition has been closed, this IA has also been rendered infructuous.
Okay.
The application is closed accordingly. Yes.
Grateful, my lord.
May I please your lordship? My lord, with the consent of the other side, my lord, I beg to mention item number 35, lordship.
Yes.
Let me be adjourned for 3 weeks, lordship.
You are for the petitioner.
I am for the respondent,
I am for
lordship.
the petition.
Petitioner is here,
I am for the petition.
35 is an income tax matter.
lordship,
You are for the Department of Income Tax.
lordship.
Mr. S. Chettial, and his standing counsel, Income Tax Department, appearing for the respondents, has sought adjournment in this case for 3 weeks so as to enable him to obtain instruction and file affidavit. Since the prayer is not opposed by Mr. P. Das, learned counsel for the petitioner, the same stands allowed. Let this matter be listed again after the puja vacations. In the meantime, the respondent may file affidavit.
Interim to continue.
Interim order passed earlier to continue.
May I
Please,
please your lordship? With the consent of other side, lordship, I beg to mention item number 49, lordship. Here, lordship, I could not file my affidavit. I request some more time, lordship.
49.
Lordship,
You are appearing as CGC.
no, lordship. I am for the BPCL council.
Mr. S.S. Roy, learned SC BPCL submits that instructions in this case are still awaited, as a result of which the affidavit on behalf of the respondent numbers
2, 3, and 4.
2, 3, and 4 could not be filed. The learned counsel therefore seeks 4 weeks further time to file affidavit. Since the prayer is not opposed by Mr. A. Dekal, learned counsel for the petitioner, writ petitioner, the same stands allowed. Let this matter be listed again after 4 weeks. Is there any interim order?
Yes.
Interim order passed earlier to continue until further orders.
Obliged.
May it please the lordship, with the consent of the other side, Mr. Counsel, Mr. S.C.K. lordship, counsel for the CGST lordship. I would like to mention item number 28 lordship. 28. We have filed our in the reply affidavit also lordship. Lordship may kindly fix the matter after vacation lordship for admission hearing lordship.
You have filed a reply affidavit.
Lordship, we have filed.
Mr. P. Sharma, learned counsel for the petitioner, submits that rejoinder affidavit on behalf of his client has already been filed, but the same is not on record. The learned counsel therefore seeks posting of this matter after the puja vacation
Lordship.
by tagging the affidavit with the record of the case.
Lordship.
Since the prayer is not opposed by Mr. S.C. Kyle and SC GST authorities, the same stands allowed. Register to list the matter accordingly. Yes.
Lordship, there is an interim order.
Interim order passed earlier to continue. Yes.
Much of.
May I please? Lordship, I beg to mention for listing of the case, Lordship. Case was last list on 2nd of August, Lordship. Case is motion stage. Lordship.
Motion.
Yes, Lordship.
Why, what is the matter about?
Lordship, matter relating to my land has occupied by the Power Grid Corporation without following the proper procedure of
Motion next week.
highly appreciated.
May I please the lordship, I beg to mention item number 1 of tomorrow's daily list, my lord. That matter kindly take up through virtual mode, my lord. Engaged counsel are from Bombay, my lord. They have some fixed matters in the Bombay High Court, my lord.
We'll see. But after the other matters are over.
Oh, my lord, okay. No obligement.
Why they are not here?
My lord, they have some matters in the High Court tomorrow, Bombay High Court. My lord. They wanted to take up the matter through virtual mode.
But this is not the reason for virtual hearing. Virtual hearing is when the council have some difficulties, not for their professional convenience.
Yes, my lord. There are some.
We'll see what
Hello.
happens tomorrow. We'll see.
Well, at the last item, it's no problem. my lord.
We'll see if time comes. Yes.
Obligement.
Lordship, with consent of the opposite party, I beg to mention item 30 for adjournment.
Item 30.
30.
You are for whom?
Air Bhuya.
On the prayer of learned counsel for the petitioner made with the consent of the other side, this matter stands adjourned for 3 weeks. Yes. Item 30. Yes. Next matter.
Lordship, I beg to mention for listing of a case,
Listing of a
listing of a contempt matter.
contempt matter. First listing.
No, last 3 occasions it has been left over.
Sorry.
Last 3 occasions that matter has left over.
Okay, after 10 days. Put a date after 10 days. Yes.
Please, your lordship, in regard to item number 31, lordship, on the last occasion, the respondent side has filed the additional affidavit, lordship. We are to file the rejoinder affidavit. Lordship may grant us some time, lordship. 31.
Ms. P. Das, learned counsel for the writ petitioner submits
Lordship,
that.
I does.
Sorry, I thus learned counsel for the writ petitioner submits that 2 weeks further time is required to file rejoinder against the counter affidavit filed by the respondent numbers
6, 7, 8.
6, 7, and 8. As such, the matter be adjourned for 3 weeks. Since the prayer is not opposed by the learned counsel for the respondents, the same stands allowed. List the matter accordingly. Yes.
Deeply obliged.
Please, your lordship, item number 13, 16 and 21. Kindly pass over for the team here.
Item 13, 16, and 21.
21.
Why?
My senior is out of state.
As paid for by the petitioner's counsel, this matter stands passed over for a week. Same order. 13, 16, and 21, same order.
Especially in one matter, we are required to amend the cost title, one page cost title. There is a notification from the High Court, your lordship knows about it. So it can be done either by the branch or the judicial register. Judicial register says permission of the court will be required. So I'm praying for listing of the matter.
Yes.
Tomorrow.
Tomorrow. Why tomorrow? Day after tomorrow.
Day after.
All right.
Daily list for motion item 5.
Third, Mr. F.Z. Mazumdar, learned counsel for the petitioner, peruse the amendments made in this petition. This petition has been filed assailing the order dated 12/6/2023, passed by the circle officer Balijan Revenue Circle, that is the respond number 4 herein, cancelling the
Partition.
order of partition earlier passed on the application of the petitioner. Mr. Mazumdar submits that the impugn order has been passed behind the back of the petitioner without giving him an opportunity of being heard. Mr. Ms. G. Hazarika, Lanet, SC Revenue Department, Assam, and Ms. M. Burman, Lanet, G. Assam have prayed for some time to obtain instruction in the matter. NOM 6 weeks since Ms. Burman has accepted notice for respond number 1, 3, and 4, and Ms. Hazarika for respond number 2, service of notice is deemed to be complete in this case. Extra copies of the writ petition, requisite in numbers, be furnished to the learned departmental counsel so as to enable them to obtain instruction. Heard on the prayer of interim relief, having regard to the facts and circumstances of the case in its entirety. Operation of the impugn order dated so and so is hereby stayed until further orders.
Item 6.
Well, this is against the order passed by the Special Tribunal, Additional District Judge Nagaon number 2, in a land grabbing case, my lord. By which the original the land, which was they claimed that on the basis of the gift deed.
Where is the order page number?
It is my lord the annexure 5 page, my lord, 43 it is started. The relevant person it is my lord. Points for determination. Basically 16.1 and 16.2, my lord. It's it on they have mentioned the
So your application has been rejected.
rejected. But interesting it is, my lord, sale on which they claim that the gift deed has been done. This is the sale is a different one, my lord. This is not the same sale deed with the mentioned.
All right, heard Mr. P. Mohanty, counsel appearing for the writ petitioners. Peruse the amendments made in the writ petition. The instant writ petition has been filed against the judgment and order dated 8/5/2023, passed by the learned additional session judge number 2, Nagaon, in special land grabbing case number 5/2018, instituted on the application filed by the writ petitioners, thereby rejecting the said application. Mr. Mohanty submits that the impugned judgment and order is vitiated by perversity and therefore deserves to be set aside by this court. NOM 8 weeks since this is all private party, is it?
All private party. It is a one of the school, my lord. Now school is, my lord, constructing the, my lord, there.
Now, how a writ petition will be maintainable against private party?
My lord, because my lord, the land giving order is there, the private party, because in school, they
Right.
under which, my lord,
Petitioner will take steps for service of notice upon the respondents. Maintainability of the writ petition is kept open and shall be gone into.
it is, my lord,
extensive-
special appellate tribunal has not considered. That is why in earlier order when High Court, my lord, they say that.
So you have to implicate someone in the state. How a writ petition is maintainable against private parties?
Because for the RTI, that is.
Whatever may be because, that is wrong because. You have to implicate someone in the state.
I will, my lord, implicate, my lord.
Yes.
And my lord, one prayer, my lord, the further construction of the school that may be, my lord, till the, my lord.
That can't be passed.
But otherwise, my lord,
Prayer for interim relief will be considered on the returnability.
must.
Item 7.
May I please, Lord?
Yes.
My lordship, in this writ petition, I have prayed for pushing of charge sheet and for a direction for re-investigation, my lordship.
You have to file a criminal review petition for this. We will not entertain these matters in writ petition. Why didn't you file a criminal petition?
My lordship, there is
The
a,
prayer in this, heard Mr. So-and-so on counsel for the petitioner. The prayer in this writ petition is for caution of a charge sheet as well as quashing of charge sheet number 09/2022 dated 15/12/2022 arising out of Panchgram police case number 177 of the 2021 registered under section 3 of the Explosive Substance Act, 1908, filed against the petitioner before the court of learned judicial magistrate first class, Hailakande. After going through the amendments in the petition, this court finds that the proceeding arises of a pending criminal the grievance of the petitioner is arising out of a pending criminal proceeding. And therefore, the remedy available to the petitioner is under section 482 of the CRPC. In view of the above, this writ petition stands disposed of by granting liberty to disposed of as not maintainable in the facts and circumstances of the case by granting liberty to the petitioner to avail appropriate remedy.
Deeply obliged.
Ms. S. Sharma, learned Government Advocate Assam is present on behalf of the state.
I can make.
The matter pertains to non-demarcation of the land of the petitioners and still other. Last occasion, the instruction was called for.
Yes, what is the instruction?
On his verbal request, my lord, regarding demarcation of the boundaries of the land mentioned in the schedule, was fixed on 8/8, but they could not proceed because of obstruction by the co-partners.
So if the co-partner obstructs, then they will not be able to do anything, is it?
Severe obstruction.
What to do?
My lord, this is the department, my lord.
Or I will hear it then. You are also not aware on the law. Don't make emotional arguments. What is the legal position here? They can't proceed because of obstruction of the co-partner. What is the way forward?
My lord,
Heard Mr. S. of Learned Counsel for the Writ Petitioner, also heard Ms. S. Sharma, Learned Government Advocate Assam, who has obtained instruction as per the order dated 23/8/2023 passed by this court and submits that as per the written instruction dated 38/2023 issued by the circle officer, Kamalpur Revenue Circle. The process of demarcation of the land could not be taken forward due to severe obstruction, within quotes, severe obstruction by the co-partners. First up, if that be so, the matter would call for deeper examination. First up, as such, have you implemented the co-partners?
No, my.
Then you withdraw and file a fresh, otherwise you will get no relief.
My lord, co-partner, my lord.
In view of
Not
the
aware, my
above,
lord, who is the
however, the co-partners are not,
petitioner is not aware of who is the co-partners, my lord, who are encouraged, but the land has been, my lord, that document.
however, the co-partners are not implicated as parties to this writ petition. As such, this writ petition is disposed of with a direction upon the respondent number 3 to furnish the names and particulars of the co-partners who are raising objection to the process of demarcation of the land within 10 days from the date of receipt of a certified copy of this order. Once such particulars are furnished, the petitioner will be at liberty to approach this court once again by filing appropriate petition. If petition stands closed.
Item 9.
Well, this matter, my lord, particularly non-refund of access GST amount, my lord.
Only objection regarding the maintainability, my lord. The necessary party has not been made, my lord, herein. Page 15 for a moment, my lord. The GST has been deducted or it has been enhanced from 12 to 18% pursuant to some circular issued by the Ministry of Finance, Government of India. It has been mentioned in our circular. So the Ministry of Finance is not a party. As per their direction, we have done it.
The amount was deposited, my lord, before the chief engineer, my lord, with the bill, my lord, against the bill.
We'll issue notice. We doesn't want to make them party. We can't dispose it of the motion state. Heard Mr. S. of counsel for this.
I appear for all the respondents.
Sorry?
I appear for all the respondents.
Also heard Mr. B. Govil and Standing Counsel PWD will submit that although the subject matter of this writ petition is pertaining to the prayer for refund of excess GST, the GST authorities have not been included as party respondent to the writ petition. As such, the learned departmental counsel has question the maintainability of the writ petition. First of all, after perusal of the amendments made in the petition, this court finds that the said aspect of the matter would require deeper consideration. As such, NOM 6 weeks since Mr. Gogoi learned SCPWD has appeared and accepted notice for all the respondents. No formal notice is required to be sent in this case. Extra copy of the requisite in numbers be furnished to the learned SCPWD within a week from today. The petitioner would also be at liberty to file appropriate application for impleadment of the GST authorities.
Similar, another item is already pending, my lord. WPC number 5 to 9.
On the request of Mr. Hobb, let this matter be listed along with WPC number
5 to 92 of 2023.
5 to 92 of 2022.
My lord, item number
Which is
10 and
stated to
12.
be Similar matter.
10 and 12 are similar.
Same.
10 and 12.
10 and 12, same order, list together.
I love it.
Item 11.
Why don't you implement them all? Why
My-
why are you unnecessarily creating trouble for your client?
No, I will complete my lord.
You are the one who's, I could have disposed of these matters today.
My lord, I'm sorry, my lord. Problem.
Item 11.
May I please, Your Lordship?
Yes.
Your Lordship, the son of the petitioner, Your Lordship, had expired due to accident in public place, Your Lordship. And as per the petitioner file a representation before the deputy.
Heard Mr. S.I. Akan, counsel for the petitioner. The son of the petitioner died in a tragic road accident that took place on 18/11/2010 on National Highway number 37. As per the standing notification dated 15/11/2014, the next of kin of the victim is entitled to ex gratia relief of rupees 2 lakhs. Full stop. The petitioner, being the mother of the victim, had submitted representations before the authorities seeking release of ex gratia compensation. However, since no action has been taken on such representations, the instant writ petition has been filed seeking a writ of mandamus. Ms. G. Hazarika, learned SC, Revenue and Disaster Management Department, as well as Ms. S. Sharma, learned Government Advocate Assam, have prayed for some time to obtain instruction in the matter. NOM 6 weeks since Ms. G. Hazarika has accepted notice for respondent number 1, Mr. B. Gogoi, SC Finance, for respondent number 2, and Ms. S. Sharma, learned G. Assam, for respondent numbers 3, 4, and 5. Service of notice is deemed to be complete in this case. Extra copies of the writ petition, requisite in numbers, be furnished to the learned departmental council so as to enable them to obtain instruction facilitating disposal of the writ petition
Obliged.
at the stage of admission. Admission hearing.
Item 14.
May I please?
Yes.
Lordship, this matter also pertinent to ex gratia. Here, Lordship, 2 DCs, Your Lordship. Our
Heard
claim is
Mr.
2 lakhs,
Sayakan,
4 lakhs.
counsel for the writ petitioner, the husband of the petitioner died in a tragic road accident on 2/1/2023. As per the so and so, rest of the things, right? Same parties,
No, Lordship, different party. Nirmala Tapo, Your Lordship, petitioner,
G. Agarika for
wife
one,
of the deceased and mother of the deceased, 2
Mr.
deceased.
B. Gogoi for 2, SC Finance for 2, and Mr. J. Hendik for 3, 4, and 5. No? Rest will be same.
Obliged. I'm deeply obliged.
Same as the earlier one.
Item 15.
May I please, Your Lordship? My lord, the petitioner's account has been raised by the respondent, Your Lordship.
Sorry,
The respondent authority has traced the account of the petitioner.
bank account.
Bank account is supported, my lord.
Respondent authority means who is the respondent authority?
State Bank of India,
State Bank. Then we'll have to issue notice.
my lord.
State Bank doesn't have a standing counsel.
My lord.
Okay.
And
Heard
for-
Mr.
for
A.
the-
Rahman Lanik.
short date may be given.
You decide which date,
Sorry, my,
you decide.
no, my, up to your lordship.
No, you have to send notice by registered
My,
post. Will it be served in 1 week? No. How much time will be required?
within 2 days, I am taking step. Your lordship.
Are Mr. A. Raman, counsel for the petitioner, aggrieved by freezing of bank account of the petitioner by the respondent bank, bracket SBI, Singimari branch. The instant writ petition has been filed, inter alia contending that the action of the respondents is wholly arbitrary and illegal. Full stop. As the petitioner's counsel has prayed for an order directing the bank to defreeze the account.
Right.
Full stop. Such an order cannot be passed ex parte and without hearing the respondents. As such, issue notice returnable in 3 weeks. Petitioner takes steps for service of notice upon the respondents by registered post with AD by tomorrow.
My,
Let this matter be listed again for after 3 weeks. On the next date, the prayer for interim relief will be considered.
much obliged.
Item 17.
Please, lordship, my lord. This matter is related to my lord for non-issuance of no objection certificate by the Panchayat department. It is required for my lord for application of the granting license of timber deportment. So my lord, he made several applications before the authority, but my till now my lord,
No objection certificate of what?
no objection certificate from the my lord respondents Panchayat department.
Do you have instructions?
No, Lordship. So we'll take a step.
We have to issue notice.
My lord, simply pray, I must sort. My lord.
So allow the writ petition today. Simple. You pass a simple order. Mr. R.S. Chauhan, counsel for the writ petitioner, peruse the amendments made in the petition. The writ petitioner is aggrieved by inaction on the part of the, who is to issue the NOC? Who is supposed to issue the NOC?
Panchayat, my lord, president, secretary, Panchayat and Panchayat department.
You don't know.
Respondent 6 and 7 million. 6 or 7.
Failure on the part of the respondent number 6 and 7 to issue the no objection certificate, bracket NOC, applied for by the petitioner, which is required for obtaining license of a timber depot. The instant writ petition has been filed. Mr. Chauhan submits that there is no valid reason for the respondent number 6 and 7 to sit over the application made by the petitioner for issuance of NOC. Hence, this writ petition. Stop. Ms.
And Bora.
N. Bora, learned standing counsel, PNRD Department, Assam, prays for some time to obtain instruction in the matter. NOM 3 weeks since Ms. Bora has appeared and accepted notice.
1, 2, 4, 5, and 7.
1, 2, 4,
4,
5,
5, and 7.
and 7. And Mr. J. Hendick, learned additional senior government advocate for respondent number 3. No formal notice is required to be sent to state respondents. Extra copies of the writ petition, requisite in numbers, be furnished to the departmental council. Petitioner to take steps for service of notice upon respondent number 6 by registered post with AD. You want Dusty? You want to serve Dusty notice?
Yes, ma'am.
In addition, the petitioner is also granted leave to serve Dusty notice to be routed to the registry of this court upon the respondent number 6 and thereafter file affidavit of compliance. Let the matter be listed again after 3 weeks as a fixed item.
Pendency shall not be banned.
Pendency of the writ petition shall not be a bar for the authorities to redress the grievance of the petitioner in accordance with law, if so advised.
Obliged.
Item 18.
Out of 11, 7 members, of the municipal board, submitted a petition for no confidence motion against chairman and vice chairman. And time elapsed, thereafter they approached the SDO for allowing them to hold a meeting as per section 43.3. If time elapsed, they can hold a meeting. But SDO has not given the, they're putting the executive magistrate and allowing the. Time has elapsed only.
You are saying yes, yes to what?
As per the provision of this, my lord, their municipal like my lord, that.
You tell us why it has not been allowed by the SDO. On motion, we'll fix it. We'll fix it for motion on Wednesday.
Lord, let me take instruction.
Yes, heard Mr. Jain Sayola, Learned Senior Counsel appearing for the writ petitioners. Aggrieved by the inaction on the part of the subdivisional officer, bracket civil, bracket close, North Salmara. That is the respondent number 3, in his failure to convene a special meeting for discussing the no confidence motion brought by the members of the
Abhayapuri Municipal Board,
Abhayapuri Municipal Board against the
Chairman and Vice Chairman.
Against the chairman of the board,
Chairman and Vice Chairman.
chairman and vice chairman of the board. The instant writ petition has been filed, inter alia contending that the respondent number 3 has failed to discharge his statutory duty by convening the meeting. Full stop. Since the reason for not convening the meeting is not apparent on the face of the record, Mr. J. Henley, learned additional senior government advocate Assam, is directed to seek instruction from the respondent number 3 and appraise this court. 2 extra copies of the writ petition be furnished to Mr.
Yes.
Henley. Let this matter be listed again on 27th of September 2023 for motion as a fixed item.
Obliged.
Pendency of this writ petition shall not be a bar for the authorities to take appropriate action in the matter in accordance with law if so advised.
Item 19.
Yes.
Lordship. Lordship, the petitioner is a registered dealer under the GST, CGST, and his registration were cancelled due to non-filing of the return. But up to 31st March 2023, he submitted the refund. All the tax dues were paid by him. In spite of that, is at the relevant point of time, GST portal was open. He has submitted all the returns up to 31st March 2023, and but his registrations of the GST were cancelled, Lordship. Thereafter, number of writ petitions were disposed of by this honorable court, Lordship.
But those were disposed of when the amnesty program was in vogue. Now that scheme has expired. What is your stand?
Lordship, he preferred appeal. That was dismissed on the ground of delay. Lordship, under section 107, the authority has power to condone delay for 1 month only. And in page 60, the appellate authority has cited the judgment of Honorable Supreme Court because the authority has no power to condone delay beyond 30 days.
Then we have to admit this matter. We have to examine it.
Lordship may examine the matter. Notice may be issued. But in the similar situated persons is the page 62, Lordship.
Those were passed when the amnesty was in vogue. I told you just now. Why are you repeating it, Mr. Agarwal? Heard Mr. S.K. Agarwal, learned counsel for the writ petitioner, aggrieved by cancellation of the GST registration of the petitioner and the dismissal of the appeal referred before the appellate authority on the ground of limitation. The instant writ petition has been filed. Mr. Agarwal submits that the petitioner has submitted his return, her return, which is updated up to 31st of March 2023. And therefore, this is a fit case where the GST registration ought to be restored. Mr. Kyle, learned SC GST authorities, on the other hand, submits that the order of the appellate court does not suffer from any illegality, and therefore he be granted some time to obtain instruction and file affidavit. We have to thresh out the law here, right? In view of the above NOM 6 weeks, since Mr. Kyle has appeared and accepted notice for respondent numbers 1 to 5, no formal notice is required to be sent in this case. Extra copies of the writ petition will be furnished to the learned department counsel so as to enable him to obtain instruction and file affidavit facilitating disposal of the writ petition at the stage of admission hearing. Are you seeking any interim relief?
Yes, Lord. In the meantime, no courtship measures should be taken.
Heard in the prayer of interim relief, having regard to the facts and circumstances of the case, it is hereby provided that no coercive measure shall be initiated against the petitioner without obtaining the leave of the court.
Except here his registration is already cancelled.
unless it is revived, we cannot take any action.
Some orders are meant for the litigants, some orders are meant for the council,
Lordship.
right? All right.
Deeply honored. Much.
Council satisfaction, rather.
May it please your lordship. Item number 20 and 23. So my friend Mr. Hawk and I are there. The issue which is arisen now can be resolved by the registrar under statute. And that we jointly we would pray, since he is rightly claiming to be a secretary. In one case, I am also rightly claiming a secretary. And two meetings are being proceeded, and the last date is 30th. Meetings dates are 29th and 30th. Let the registrar take a call before that date so that the matter can be resolved at that level.
Which is the other matter?
20 and 23.
20 and
23. It's a joint prayer. 23 is concerning AGM. 20 is concerning secretarial.
just a minute, just a minute. You have filed item 22.
Item 20, another matter, not related to this.
It's 20 and
23. In 20, the cause of action at page 20, the authority is allowing him to continue as the secretary, where I also claim as the secretary.
in item 20, who is the counsel?
I am the petitioner.
What is your case really?
My case is that he was the secretary. He was removed from that post by a resolution number 1 on 16/6/2023. Resolution number 3, I was brought in. Now his removal was suspended by the authorities. And that
He means who? Which respondent?
respondent number 6. The removal of respondent number 6 was suspended by the authorities. And thereafter, this honorable court had made an observation, which we have also annexed, that the order was without authority. So in that view of the matter, notwithstanding the order of suspension, his removal stands. And I also stand. So we both claim to be the secretary together. The registrar is to take a call under 49(2)L as to who should be there. He is not taking a call. We have approached the honorable court. Number 1. Insofar as item number 23 is concerned, in a statutory meeting, appeal, the registrar has held that I am the chairman of the society and someone was the vice chairman. So when we proceed to hold the AGM, parallelly, unilaterally, he also proceeds to hold the AGM. So 29, we have fixed the date. 30th, he has fixed the date. Let the registrar take a call. What is to be done? Who is to stay?
One by one, then let's first finish item 22. Where is the order by which is? Where are the orders? You show me the case.
So far as 25 and 26. 25 is his removal. Resolution number 1. It has been unanimously resolved in today's meeting that as per provisions of section 38(2) of the Assam Cooperative Societies Act, Shri Vikas Das secretary be removed immediately from the post of secretary of the society. His removal. I come in 26.
Yes.
Resolution number 3. Today's meeting has resolved that Sri Sanjay Das be immediately appointed as secretary of the society and his remuneration has been fixed at so and so per month. Now at page 33.
Yes.
The assistant registrar of cooperative societies, he directs to make an inquiry and pending that, it's said that the order be suspended. If I may read at page 36, with reference to the above noted subject, I am to inform you that you had submitted the proceedings of the meeting of Board of Directors held on 16/6/2023, wherein the undersigned.
You are reading from which page?
Page 36, my lord. With reference to the above noted subject, I am to inform you that you have submitted the proceedings of the meeting of Board of Directors held on 16/6/2023, wherein the undersigned had approved the same with his opinion. In respect of resolution number 1 of the proceedings of the same BOD, the members of the BOD have submitted complaints one after another. Thus, a departmental officer has been appointed to make an inquiry in respect of the allegations. Thus, the approval in respect of resolution number 1 of the meeting of BOD, dated 16/6/2023, has been suspended for the time being. Till completion of the inquiry, Shri Vikas Das is allowed to carry out the function of the society.
Then what?
This honorable court in an order dated 25/7/2023, operative part at page 59, I mean, 51, operative part at page 51. The first paragraph towards the last. Taking into account, what she was, first paragraph. Taking into account section 49(2)L of the Act of 2007, it is prima facie appears that the exercise of jurisdiction by the Assistant Registrar of Cooperative Society in issuing both the communications enclosed as Annexure 9 and 10 dated so and so are without authority. Pausing for a moment, his suspension was held to be without authority, albeit it was an observation only, not a final thing.
Yes.
It is at this stage where I claim to be the appointed secretary by virtue of the resolution number 3, and he claims to be operating by virtue of the order of suspension. And we further say, since the honorable court has observed that it is without authority, he may not continue. This is the difficulty where we are posted in, both of us, and the jurisdictional registrar can take a call on that. Because the meeting is approaching.
Registrar cannot override. You have to seek a review of this order.
Very well. Therefore, we have challenged this order.
You have to seek a review of this order. Whether the court has struck down.
No, court has not struck down. Court
Then
has
you will
observed.
continue.
Therefore, we are challenging this order in this writ petition.
Court's order.
Not court's order. 27(6) order by which the order was suspended, his removal was suspended, was observed by this honorable court to be without authority. Albeit no formal challenge was made therein. Therefore, by way of this writ petition, we are putting a formal challenge to that. And we are taking support of the observation of this honorable court in the writ proceeding.
Which appeals were there before the registrar?
Before the registrar, as to who would be the chairman or not, were before the registrar, and when order dated 38/2023, it was held that the chairman would be so and so. To complete the narration, we have annexed that document at 56, but I am not on that meeting.
Where is the board's resolution dated 5/7/2023?
5/7/2023, page 40. Resolution is not there. Resolution is not there. 5/7, because that is regarding the chairman, vice chairman.
No, but the learned single judge observed that this accordingly board's resolution of the Cooperative Society dated 5/7/2023 stayed. Where is this resolution? I
That
asked you.
resolution relates to chairman and vice chairman. It is
Where is the
It is
resolution?
not a part of this document because it is not relating to me also. So the writ petition was preferred, challenging the action taken by them against the chairman and the vice chairman. Although I was also a writ petitioner. Direction was passed with these observations that go for the appeal. Appeal was allowed.
What do you say?
He also agrees to it.
There is a remedy, lordship. We can approach the register, lordship, under
Oh,
section.
he changed his voice just now.
No,
Can
he's
you
supporting.
send
No, he's not saying.
He can approve the register, lordship, under section 1
You want the writ petition to be dismissed?
Matter may be remanded back to the register, lordship, or decide the issue, lordship. He has the authority, lordship.
Mr. S. Banik, learned counsel.
But before 29, because 29 is the date for the AGM, and we have section 39, the last date is 30th, when otherwise the board may stand dissolved.
Mr. S. Banik, learned counsel appearing for the writ petitioner. Also heard Mr. V. Rajkua, learned SC, Cooperation Department, Assam, appearing for the respond numbers 1 to 4. And Ms. S. Sharma, learned G. Assam, appearing for respond number 5. Mr. Eviction, learned counsel is present on behalf of respond numbers 6.
7, 8 may be struck off also, madam.
Respond number 6. Full stop. The controversy, the central controversy involved in this writ petition pertains to question of legitimacy of the legitimacy of either the writ petitioner or the respond number 6 to continue in the office of Secretary of the
Dibru Dangori River Part 1 Cooperative Society.
You have not even named the society.
Madam, Dibru Dangori River Part 1.
Where does one find the name?
Page 10. Paragraph 2.
Of the Dibru Dangori River Part 1 Mean Samabay Samiti Limited. Full stop. It appears that while resolution number 1 adopted in the meeting of the SS Limited held on 16/6/2023, the respondent number 6 was removed from the post of Secretary of the Society, and as per resolution number 3, the writ petitioner hearing was appointed as the Secretary of the Samiti. Consequently, the petitioner continued to function as the Secretary of the Samabay Samiti Limited. However, the Assistant Register of Cooperative Societies, Tinsukia, that is the respondent number 4 herein had passed order dated 26/7/2023, suspending the approval of resolution number 1 of the Board of Directors of the SS Limited, adopted in the meeting dated 16/6/2023. As a result of which the respondent number 6 was restored back on office. When the above position was obtaining, the learned single judge of this court had passed judgment and order dated 4083/2023 in a writ petition instituted by the present petitioner and two others. Thereby observing that the order dated 27/6/2023 passed by the respondent number 3 was without the authority of law. However, since the subject matter of the said writ petition was pertaining to the question of validity of the resolution adopted in the board meeting dated 05/07/2023, the learned single judge did not pass any effective order pertaining to the order dated 27/6/2023 issued by the respondent number 4. Full stop. Today, when the matter is called up, Mr. Banik, learned counsel for the petitioner, submits that so as to end the uncertainty obtaining in the matter, the best recourse would be for this court to direct the respondent number 2, that is the Register of Cooperative Societies, to decide on the question of legitimacy of the petitioner vis-a-vis the respondent number 6 to continue in office of Secretary of the Society. Full stop. Since the AGM of the society has been scheduled
On
29/9/2023, an attempt be made to decide on the said issues prior to the holding of the AGM. Mr. ABT Hawk, learned counsel for the respondent number 6, as well as Cooperative, Mr. Rajkwa, learned SC Corporation Department, as well as Mr. ABT Hawk, learned counsel for the respondent number 6, have also fairly agreed to such a recourse. In view of the above, without, what will he decide? You have to file some appeal?
he can take a call on this because of the next writ petition, wherein who is to convene the AGM. 2 notices have been issued, one by me, one by him. While he decides that matter, parallelly, he also decides as to who is holding the post of secretary. The one meeting will be there.
In view of the above, without commenting on the merit of the claims and counterclaims of the parties, this writ petition stands disposed of by directing the respondent number 2 to decide on the question of legitimacy of the writ petitioner vis-a-vis the respondent number 6 to continue to function as the secretary of the board, preferably within a period of 10 days from the date of receipt of.
29 is the.
I can't say that. 10 days from the date of receipt of a certified copy of this order. The aforesaid aspect of the matter can be looked into and a decision be rendered either by the respondent number 2 himself or any competent officer authorized by him on that behalf. Whatever be the outcome of the process, the same be communicated to the contesting parties in writing. It is not going to be possible. It's not going to be possible. In 10 days, who is going to appear when?
Since the AGM is on
Correct.
29, prior to.
From tomorrow onwards, the petitioner and the respondent number 6 will remain present before the respondent number 2 every day. You have to be present every day.
Yes. Not from tomorrow, from a day after, because they have to come from a distance.
We have to remain present because all this process, how it can be done in 10 days time, Mr. Banik?
No, I'm not disputing that. I said they have to come from Tinsukia, let one day be gap be there. From day after.
Oh, this is not, these things will not be decided in next 1 month. Be sure about it. The officers have other things to do. They are not sitting here only to decide. A decision in the matter be taken as expeditiously as possible, preferably before the holding of the AGM of the society. The respondent number 2 may cause notice to be served upon both the parties before and give them a personal hearing before the final order is passed. With the above observation, writ petition stands disposed of.
So far as item number 23 is there. So far as my line is concerned, the AGM has been.
Everyday present is not required.
So far as the writ petition is claiming the secretaryship, the writ petitioner is the chairman. Now, this chairman has been held by the ROCS in a statutory appeal. So we have fixed the meeting on 29th. He claiming to be a secretary has fixed it on 30th. That will be decided. Which one to stand?
I have fixed the
On
AGM
30th?
lordship.
But I will not lay down any timeline. This is not possible.
But in since that is there, which one to stand?
Then we'll stay the AGM.
No, lordship.
No?
8 members are approved me lordship as a secretary to hold the.
I will
AGM
not
lordship.
lay down any timeline for the respondent number 2 to decide the matter within 29th.
May I rephrase my
It is,
submission?
this
May
matter is
I-
rejected.
May I rephrase my submissions? I try to persuade me. Like what are they say?
So you people must understand, these registers are not
I
sitting here
am
only
not
to
on
decide.
that. I am not at all on
They
that.
have just submitted a representation, your lordship.
We have submitted
They
representations also.
Just
On
listen.
5/9, 15/9, we have submitted representations.
Need some time.
It is there.
You did not say that. I am only mentioning. You are agreeable to every prayer he is making?
No, I'm saying in one of the petition, your lordship.
Uh,
They have submitted a petition just now only, your lordship.
If
That is
we have
it.
submitted, five we have submitted, the agony which we are there, I'm trying to persuade myself, if I may submit fairly. Since the consequence of non-holding an AGM legitimately by the statute.
Then you give up that prayer. AGM cannot be deferred.
No, AGM is not to be deferred.
So he will decide it as expeditiously. as possible.
Then-
There can't be decision.
Then in that case, there will be 2 AGMs.
Correct.
The validity of.
Whatever happens, happens. We cannot compel a register to decide a matter within 10 days because there are some procedural issues involved in it.
In that case, let this matter be for motion before 29. Let them get the instructions on what they have to say on the representation we have submitted 15th for motion.
Where is the representation?
Representation at page 62. '65 is the last part which will be relevant.
How this thing arose to 2 chairmen?
No, one chairman.
Huh.
I am the chairman after the registrar had passed that order on 38/2023 in a statutory appeal as directed by this honorable court. As a chairman, I proceeded to convene the AGM and notices were being issued. Unilaterally, he also proceeded to issue notice on the strength of the order of suspension. Now 2 dates are coming, 29 by the chairman, held by the registrar, and 38
What
by.
happened,
That is a
Lordship?
difficulty.
He is holding the
Why are
meeting.
you shooting in your foot? if you have been declared to be the chairman, why are you putting your head in the guillotine?
We-
His action will be illegal.
I understand,
Then-
but unless I bring it to notice of the honorable court, it will not be fair. on our part.
Nothing.
Then for motion before.
You
29
withdraw it, otherwise you will be shooting in your foot, Mr. Bonik. You have been declared by the,
I understand.
why are you coming to this
I
court?
squarely understand. Would it be on next Monday? Because I'll have the instructions to be on that.
On the prayer of Mr. Bonik. This is a completely misconceived and
I-
wrong advised petition.
No, not.
Your
at first.
client
It
has
was-
been-
It was, I advise others.
No, and the register has held your client to be the.
Correct.
Why have you come to the court to declare?
As an officer of
it
the
is-
court, I put it on record. I advise absolutely against the filing, but apprehending that the authorities are handing up with him so far as they are not even acting on our representations. To be fair, we file a petition. That's all. I apprehended so. I told them also beforehand on Monday.
Absolutely
On
wrong.
Monday.
You will be in trouble if you
I
don't
got
withdraw
it.
this.
On Monday.
On the prayer of Mr. Bonik, this writ petition stands adjourned and shall now be listed for motion on Monday.
Grateful.
You will be in big trouble, Mr. Bonik.
Not-
This is a completely
I got it.
ill-advised writ petition.
Not illegal. I advise the other way around.
Then who, your client
They
is
are
overriding
insisting,
your
they are
advice.
insisting that they are handing gloves with us. The things
Are
have
you
got too
saying
far.
your client is overriding your
Not,
advice
not quite.
and
but to that
compelling you to work?
To that extent, if the something else happened before the AGM is held, but we don't take personally. Okay.
Item 22.
May I please, Your Lordship? My lord, in this case, what happened, petitioner is was appointed secretary of the board, my lord. And my lord, he was in custody for some, my lord, allegation, my lord. And during that period, AGM was held on annexure 1, page 22, page, my lord. 20, my lord, AGM was held and AGM election held, my lord, and board was elected, my lord. Thereafter, the, my lord, one-man committee has passed an order on page 35, annexure 2. Annexure 2, page 35, my lord. In pursuance of police case number so and so, under the Moirabadi police station and BOD resolution number so and so, Luchanbadi, Raful Amin, secretary so and so, is hereby suspended from the post of secretary, suspended, my lord, of the secretary with immediate effect. Thereafter, petitioner was released from the custody and he filed an application before the, my lord, next page 36, before the, my lord, president of the board, elected board, my lord. Under the, my lord, Cooperative Act, my lord, board is the authority to decide the fate of the secretary, my lord. Then, my lord, a copy was also forwarded to the ARCS annexure 4, page 38. ARCS has directed, my lord, to take necessary action. My lord, annexure 5, page 39. The board has relevant portion at page 40, my lord. Resolution number 2. As per agenda number 3, today meeting on 6/1/2023, the secretary of so and so, Ruful Amin, was suspended from the post of secretary in connection with Mirabadi PS case number so and so. Today meeting discuss about withdrawal of the said suspension. As per discussion till now, Ruful Amin secretary is not convicted by the honorable court. Therefore, today's meeting unanimously resolved after discussion that the suspension of Ruful Amin secretary is withdrawn and allowed him to continue all works relating to secretary of the Luchanbadi Samabaya Samiti, my lord. Thereafter, my lord, petitioner is working, my lord. Now, my lord, annexures 11, page 60, my lord. Page 60. And thereafter, my lord, some order were passed, my lord, by the register, that is impending hearing. And finally, my lord, I am working. At this stage, my lord, page 60 order was passed, my lord.
Yes,
So I am against this order, ma'am.
yes. What is this order?
My lord, with reference to the subject cited above, I am directed to request you to ask the one-man management of the society to run the affairs of the society and hold the AGM election with the existing secretary of the society, IC's in charge secretary. During my absence, one salesman was appointed as in charge secretary. After that, it was withdrawn. I am continuing, my lord. Before that, also, my lord, a resolution was taken by the one-man committee again at page 55, annexure 10, my lord, in my favor, on, my lord, 16/8/2023, my lord.
So what is wrong with this order?
My lord, I am the secretary, my lord. In my place, my lord, my lord,
But you have not been reinstated.
restated, my lord.
Where is the order?
By resolution, my lord, at page, my lord, I'm showing, my lord. After my application, then page annexure 5, page 39, my lord. relevant portion, page 40. I am reading out my. As per agenda number 3, today's meeting. On 6/1/23, the Secretary of Lochanbari Sombai Samiti, Sri Ruful Amin, was suspended from the post of Secretary in connection with the Muirabari PS case number so and so. Today meeting discussed about withdrawal of the said suspension. As per discussion till now, Ruful Amin Secretary is not convicted by the Honorable Court. Therefore, today's meeting unanimously resolved after discussion that the suspension of Ruful Amin Secretary is withdrawn and allowed him to continue all the works relating to Secretary of the Lochanbari Sombai Samiti. Under the Cooperative Act, my lord, it is the board to decide. Section 49, my lord. And board has decided in my favor.
Then what has happened? This the impugn order is against this resolution.
Yes, my lord.
Lordship may kindly come to page 53, your lordship. It is the order dated 19/7/2023 passed by the registrar, your lordship.
Yes.
Relevant portion is at page
That I have also challenged.
53, your lordship.
Yes.
It is seen that the AGM election of Lochanbari Samavai Samiti Limited was held on so and so. The first agenda is election. The other agenda of the AGMs were held after election. As per clause 3E of the Assam Cooperative Society's election rule 2019, the other agenda of the AGMs would be completed within 12 noon on the date of the AGM, and after that the election be started. But in this case, election was started at 9 AM with other agenda. The result of the election was declared on 24/12/22. However, the resolution of the meeting was prepared on 22/12/22 and the said proceedings were submitted to the ARCS Morigaon so and so, which was approved by the ARCS Morigaon so and so. It is alleged that the AGM election of so and so was started at 9 AM on so and so, which had violated the provisions of the Assam Cooperative Society's election rules. From above, it is found that the election of so and so society under Morigaon district was not convened as per procedure and law, but with irregularities, and therefore I so and so, Registrar of Cooperative Society Assam, do hereby cancel the approval accorded by the ARCS Morigaon and ask the Joint Registrar of Cooperative Societies Guwahati Zone to appoint a departmental officer to hold the phrase AGM of the said society. Further, the concerned returning officer, observer, and ARCS Morigaon are hereby asked to show cause to their negligence in duty in holding the AGM of the society. Regarding the appointment of the secretary of the said society, the next BOD will take decision on the matter. Petition is hereby
This is
disposed of.
regarding appointment matters. My suspension was withdrawn. There cannot be any appointment.
But where is the decision on the appointment of the secretary as per 19 July 2023? Is this order under challenge?
Yes, madam, I'm challenged here in.
You
I have also-
challenge 19/7
Yes, ma'am.
2023.
This order is also challenged under challenge. I have challenged it. Because my registrar has no authority to decide my fate. It is the board to decide. And
Right,
board,
then we have to issue notice then.
yes, my lord. And status quo is on today, my lord. I'm not praying for stay, my lord. Status quo is on today because I'm holding the charge.
Then who is removing you?
My lord, last order, my lord. I am showing my page 60, annexure 11. Before that, on August, my lord, one-man committee appointed by the my lord registered order has allowed me to hold the charge, my lord, 16/8, annexure 10. And annexure 11 order passed, my lord, saying that, my lord, IC secretary should hold the charge, my lord. That is in complete violation of the board. And that order was passed in 19/7, my lord, registered order. Before
I
that,
heard Mr. J.M. Chaudhary, Learned Counsel, appearing for the writ petition. I also heard Mr. G. Bordole, Learned SC Corporation Department, appearing for the official respondents. The writ petitioner was earlier appointed as the secretary of Lochanbari SS Limited pursuant to his arrest in connection with Muirabari
Muirabari PS case number, my
Muirabari PS case number
lord.
that is not.
My lord, in page 35, my lord. Muirabari PS case number, my lord, 230/22. 2022.
230/2022 registered under section 120 bracket capital B bracket close /201/403/409/417/468 of the IPC, read with section 7 of the E full stop C. What is E full stop C?
Essential Commodities Act.
Essential EC Act.
Yes.
The petitioner was removed from the post of secretary and an suspended from the post of secretary and an in-charge secretary was appointed. However, subsequently, by the resolution dated.
My lord, dated, my lord, 18/3/2023, page 39.
18/3/2023, the board of the Samavai Samiti had reinstated the petitioner in the post of secretary and allowed him to continue to work as the secretary of the board. According to Mr. Chaudhary, his client is presently functioning as the secretary of the board. However, being aggrieved by the order dated 2/9/2023 issued by the Assistant Register of Cooperative Societies (GEN)
Additional.
Additional Register of Cooperative Societies (GEN) whereby the one-man committee was directed to function as the secretary of the board for holding the AGM of the election of the society. The instant writ petition has been filed. The learned counsel for the petitioner submits that as per the provision of section 49(2) of the Assam Cooperative Societies Act 2007, it is the board which is the final authority to take a decision on the question of appointments to continuity in office of the secretary. First up, as such, since there is an unanimous resolution of the board to permit the petitioner to function as the secretary, the respondent number, additional register is the respondent number
3, my lord.
The respondent number 3 did not have any authority or jurisdiction under the law.
Respondent
Issued
3.
the impugn order dated 2/9/2023. First up, Mr. Bordolo learned SC Corporation Department prays for some time to obtain instruction in the matter. NOM 4 weeks since Mr. Bordolo has appeared and accepted notice for respondent numbers
1 to 4, your lordship.
1 to 4.
No, 1 to 5, your lordship.
1 to 5. No formal notice is required to be sent to the respondents. Extra copies of the writ petition be furnished to the learned department counsel, requisite in numbers, so as to enable him to obtain instruction. Petitioner to take steps for service of notice upon respondent number 6 within 3 days from today by registered post with AD. Hard on the prayer of interim relief, having regard to the facts and circumstances of the case, as well as the mandate of section 49(2) of the Act of 2007, it is hereby provided that operation of the impugn order dated 2/9/2023 annexure numerical 11 bracket close to the writ petition shall remain suspended until further orders.
Orders may be item 24.
Lordship, the respondent number 3, as the applicant has filed this application praying for altering or modifying the order dated 22/2/2023 passed in WPC. Lordship is that in the objections affidavit in opposition, they have filed certain documents that indicates that they have been paying us some amount of money from the month of February till August, July. But this application, these statements have never been filed since 2018 to 2023. Only after filing the writ petition they have been filed, thereby indicating that they have not paid us any money till today, except an amount of 7 lakhs. My limited prayer will be, if they continue to pay us and earlier payment, we may not have much objection against them. Only thing, they have not paid us for 5 years. The question of auditing does not come when the certain document has to be there before me so that I can audit it. They did not file a receipt and statements, how much they have earned, how much they have spent. So limited prayer will be that they should be allowed, they should be asked to pay the amount, outstanding amount to me. For that, there may be sitting before among the representatives of the people.
You can't get a relief in his writ petition.
Lordship,
You
that's what
want
is a
the-
civil dispute, it is a civil dispute.
You want the order, which order to be vacated?
Lordship, order dated 22/2/2023.
Right, now he has filed objection.
Lordship.
Do you want to file any rejoinder? If
may-
not, we'll take this to be correct and accepted. And then
Lordship,
proceed with the
I
matter.
I may need some time for that. Another,
Okay, how much time do you need?
by next week, that may better be can be fixed.
All right. Mr. B.K. Bhagavati, learned counsel for the applicant submits that a copy of the objection filed by the writ petitioner stroke OP in this IA has been served upon him only yesterday.
Yes,
day
day
before
first.
Yesterday. Since the objection discloses certain facts for the first time, he be granted a week's time to obtain instruction in file rejoinder.
Lordship.
As such, a prayer has been made to post this case again after 10 days. Mr. B.D. Decker, learned counsel for the writ petitioner, does not have any objection with the prayer is allowed. In view of the above, office to list this case again as a fixed item after 2 weeks in the column of order bracket stay vacating. The applicant may file rejoinder within a week from today by serving advance copy upon the
Lordship.
respondent's counsel.
Interim
Interim order passed earlier to continue in the next listing.
apply.
You continue to pay, that's all, will resolve
no,
the matter,
in
will
fact,
dispose of the matter.
I would have continued, well, they reprimanded, they don't pay because matter is sub judice.
She's only
So I-
within the year 2023 after filing the petition,
In
not
fact,
before us.
in fact, I am
Single
suffering
penny has
for
been
non-audit. That's
IBRC is enjoying the property without paying any penny
So
to
you
me.
obtain instructions, will close it on the next day.
Lordship.
What stay vacating?
my lord.
Let him not vacate the premises and pay rent, that's all.
Only thing outstanding also, because after all, the corporation is dying. We have to pay some huge amount of money.
So we'll give you liberty to
Lordship.
proceed against him for other, continue, he will continue, she will continue to pay the current rent. And for the outstanding, you have to initiate appropriate action as per law. That's the law.
Lordship.
That's the order will pass.
Lordship.
Yes.
Order impleadment of party item 25.
My pleasure. Lordship, by this application, the applicant sought for impleadment as the party is one number 7 and 8 in the writ proceeding.
7 and 8.
7 and 8. As
Who are the opposite parties here?
the writ petitioner, my lord.
You want to implead whom?
The applicant, my lord. Applicant number 1 and 2.
Applicants want to get themselves impleaded.
Yes, but filing this interrogatory application for impleading, my lord, as respondent number 7 and
So your clients wants to get impleaded.
yes,
As respond number 7 and 8.
yes.
But already there are respondent up to 13 in the writ petition. Who are these opposite party numbers? 7, 8, 9, 10, 11, 12, 13.
No, my lord, in the writ petition up to 6, my lord.
No, but I find in page
But in
6
the
and 7.
application, my lord, the opposite parties, the writ petitioner are ultimately come to the opposite parties, my lord. That's why the numbers of parties increased, my lord.
Why you want to get impleaded?
My lord, they are the president and secretary of the Gornagar Bazar Honor Association. My lord. They have filed the writ petition in earlier occasion. They have.
Not actually, my lord, they are the encroachers, my lord, and we want eviction.
We can't decide that. What is it? What is your stand on this application for impleadment?
Maybe impleaded, my lord, because at the time of hearing, my lord, it will be
Yes,
clear.
you
my
are the president and secretary of?
The Gornagar Bazar Honor Association.
What bazaar?
Gornagar Bazar.
Gornagar
Honor
Bazaar.
That is not registered, my lord. That is not registered.
Take down, heard Mr. R. Islam, learned counsel for the applicant. Also heard Mr. AFNU Molla, learned counsel appearing for the opposite party numbers 7 to 13. Who are the writ petitioners are opposite party numbers?
1 to 7.
1 to 7. Who are the writ petitioners in the connected proceeding? Miss N. Bora, learned SC, PNRD Department, Assam, and Mr. BJ Talukdar, learned senior counsel, are present on behalf of the official respondents. This IA has been filed by the two applicants seeking their impleadment in the connected writ petition. Mr. Islam submits that the applicants are the president and the secretary respectively of the Gornagar
Bazar Honor Association.
Bazaar Owner Association, and therefore they are interested in the outcome of the proceeding. Although Mr. Mola has refused to recognize the locus of the applicants, the status of the applicants as president and secretary of the committee, which, according to him, is not a registered association. Yet the writ petitioners council submits that he has no instruction to file any affidavit, any objection opposing the prayer made in the IA. Similar is the stand of learned departmental counsel appearing in this case. In view of the above, having regard to the statements made in the IA, which have remained uncontroverted, and after hearing the submissions made at the bar, this court is of the opinion that the prayer for impleadment made by the applicants deserves to be allowed. As such, the applicant numbers 1 and 2 are hereby impleaded as respond numbers
7 and 8.
7 and 8 in the connected writ petition. The applicants to file amended cost title within 10 days from today, register to list the writ petition thereafter for necessary orders. ISL disposed of.
Obliged, ma'am.
Item 26.
May please your lordship. Lordship, we have filed this impleadment petition, lordship,
Yes.
to implead lordship, the opposite party numbers 5 and 6, your lordship. They are the GMC commissioner and the associate planner, your lordship. What happened, lordship? Initially, lordship, in the writ petition, we have challenged the demolition order passed by GMDA, lordship. Thereafter,
You want to implead whom?
GMC, lordship, because during the pendency of the matter, a GMC has issued another order, lordship, letter, lordship, page 16, whereby they have asked us for no objection certificate, approved plan, occupancy certificate. That's why we are.
Yes, GMD, any objection?
No, no.
Heard Mr. DJ Das, learned counsel for the applicant. Also heard Mr. Chettial, learned counsel appearing for the GMD. Learned standing counsel.
Teen existing council.
Then why don't you call him? Ask him to appear. Now also heard learned standing counsel GMD appearing for the respond numbers 1, 2, and 3. And Miss Sharma learned G. Assam for respond number 4. This IA has been filed with a prayer to implead the Guwahati Municipal Corporation and the associate planner of GMC as respond numbers 5 and 6 to the connected writ petition. I have perused the grounds stated in the application. The learned standing counsel GMD submits that he would have no objection if the prayer is allowed. In view of the above and having regard to the statements made in the IA, the prayer for impleadment stands allowed. The Guwahati Municipal Corporation (GMC) represented by the commissioner and the associate planner GMC be impleaded as respond numbers 5 and 6 in the connected writ petition. The the applicant to submit amended cost title to the writ petition within 10 days from today, register to list the matter thereafter for orders. IS stands disposal.
Much obliged.
For admission, item 27.
In this case, my lord, from the year 2015, my lord, onwards, my lord, my lord, before the deputy commissioner, in respect to allotment of 2 bighas of land from this non-government organization, my lord. Here, my lord, already report submitted by the circle officer regarding that classes of that land, my lord. Annexure G, my lord, page 38. That land can
What
be
is that
allotted.
ready for disposal, Mr. Sharma?
Lordship, whether the mandamus can be issued as because he is occupying a government land, he has made a prayer.
Second land also.
Second land or something land, Lordship, but your Lordship kindly see the last sentence of the circle officer. It is very tactfully he has written in that letter, Lordship. He is occupying, now he is praying that land should be allotted to them. So if the authority pleases, the said remaining vacant land may be allotted.
So what is your stand? Who is the authority here?
No, he has, if your lordship, only the consideration, that only that order may pass lordship, or otherwise lordship, whether that direction can be issued lordship, he is occupying a government land.
No, he's, have you submitted an application for
Yes, yes.
allotment? Where is it?
This is, my lord, everything's are clear, my lord. I have annexed here, my lord, page
Which-
40.
Page 40.
Yes, my lord. Right at that, application, my lord, also. Oh, sorry.
Where is your application?
Yes, my lord. All applications are here, my lord. I have submitted classes of the land also, my lord.
All right, after vacation, you come prepared.
No, my lord, I'm submitting. Yes, my
Section
lord.
49,
14.
regarding government funding in the disputed land. Fine, I know.
No, I don't. Classes of the land.
This is what government funding.
Page 29, my lord.
29, no? This is to the circle officer.
Yes, my lord.
No such application to the deputy commissioner.
You make an application before the competent
Lordship
authority.
and,
They will consider in accordance with law.
Lordship.
I heard Mr. H.K. Das, Learned Counsel appearing for the Mr. H. Das, Learned Counsel appearing for the writ petitioner. Also heard Mr. H. Sharma, Learned Additional Senior Government Advocate Assam appearing for the respondent numbers 2. Respondent number 2.
2 and 3, Lordship.
Respondent numbers 2 and 3, Ms. N. Bordeley, Learned Standing Counsel, Revenue and Disaster Management Department, is present on behalf of the respondent number 1. Full stop. The writ petitioner number 1 is a non-governmental organization registered under the Societies Registration Act 1860, and the petitioner number 2 claims to be. Who is the petitioner number 2?
Petitioner number 2, my lord, is the, my lord, for the Indian Monsa is the petition number 1, and petitioner number is the, my lord, secretary of this NGO.
Secretary of the NGO.
Yes, my lord.
They have approached this court by filing the instant writ petition, seeking a writ of mandamus upon the authorities to consider the prayer for allotment of unused government land situated at Hojai, Singari Basti, Kisamat under Hojai Revenue Circle, Noga, pertaining to Dag number 448. The land in respect of which the petitioners are seeking allotment is admittedly a plot of Sarkari land. Your clients are in occupation.
Yes, occupation, my lord.
According to the petitioner's counsel, his clients are in occupation of the land, which is unused, and therefore there is no impediment on the part of the respondents in considering the prayer made by the petitioners. Full stop. Mr. H. Sharma, Learned Additional Senior Government Advocate Assam, on the other hand, submits that there is an elaborate procedure laid down under the various rules and notifications for dealing with applications for allotment of land. And if the petitioner makes a fresh representation before the considered authority, before the competent authority, their request would certainly be considered in accordance with law. Although there are some documents annexed to the writ petition, indicating that the petitioners had earlier submitted application for allotment before the secretary to the government of Assam Revenue Department on 5/11/2015. Yet, due to lapse of time, it is possible that such application of the petitioner may not be available in the record any further. As such, without commenting on the merit of the claim of the petitioner, I dispose of this writ petition by granting 8 weeks' time to the writ petitioners to submit a fresh application before the competent authority seeking allotment of land by giving the particulars of the land in question. Full stop. If such application is submitted by the petitioners by enclosing a certified copy of this order, the request be considered in accordance with law and an order be passed therein within a reasonable time frame. With the above observation, this writ petition shall be disposed of.
May I please, Your Lordship? I'm appearing on behalf of respondent number 6 to 12. So I need some time to file affidavit, Your Lordship.
Yes.
This is regarding self permission to be issued by the deputy commissioner. Now petitioner are aged about 70 years, 65 years and 60 years.
How much time you want?
2 weeks.
We'll have it fixed after 2 weeks.
Yes.
No further time. Heard Mr. M. Mondal and counsel for the petitioners also heard Mr. H. Sharma, learned additional senior government advocate Assam appearing for the official respondents, Mr. P. Upadhyay.
NN Upadhyay.
Upadhyay, learned counsel appearing for the respondent numbers 6 to 12. Submits that 2 weeks time be granted for filing affidavit on behalf of his client. First up, although Mr. Mondal has expressed urgency in the matter, yet the prayer made by Mr. Upadhyay deserves consideration by this court. As such, this writ petition is directed to be listed again on 6th of October 2023 as a fixed item. The affidavit on behalf of the respondent number 6012 be brought on record in the meantime by serving advance copy upon petitioner's counsel.
October 26.
6th of October.
6. Date of place.
May I please, Lordship?
Yes.
The petition is against the dismissal of the revision petition for non-prosecution, Lordship. In fact, what happened, the notice for issue dates fixed for revision case was not at all received by us. On that allegations, we have also made a representation to the revisional authority, which was also rejected. The first impugned order is page 30, Annex 3, Lordship.
What you consider?
Lordship, I have not received inside lots of short date, Lordship. I'll be receiving.
Heard Mr. A. Todi, learned counsel for the petitioner. Also heard Mr. B. Chaudhary, learned standing counsel, Finance and Taxation Department, Assam, who prays for and is granted further 3 weeks time to obtain instruction.
Lordship, 2 weeks.
2 weeks time to obtain instruction, facilitating disposal of the writ petition.
Lordship,
At the stage of
small matter
admission.
otherwise.
Let this writ petition be listed again after 2 weeks as a fixed time.
Much obliged.
May it please your lordship. Grievance of the petitioner is that, my lord, she has been deprived of her property, my lord, a house by the police authority, my lord, without any authority of law, my lord. The ground of the case is that, my lord, the petitioner has rented out a portion of her house, my lord, the first floor of a building, my lord.
Deprived how? Deprived how?
My lord, by keeping lock and key since 2013, my lord.
Actually,
You
Lordship,
come after 10 years, yes?
no, Lordship, the house was giving rent to the Saroda company, Lordship. Accordingly, the affair was lost. Certain documents as well as furniture were seized and it was kept under lock and key. It was sealed in presence of a district magistrate, Lordship. So accordingly, Lordship, we have filed an application before the SDJM, Bilasipara, to so that this the seized articles can be kept in our police station and the vacant position of the residents can be given to the petitioner. But Yeah, we are still awaiting for the order of the SDGM. That is the issue, Lordship.
You have seized immovable property.
No, Lordship, that as because the property, as because Lordship, that is the information we have received. That's what I want to inform you that the sealing of the said branch office of Messrs. Sarada Realty India Limited has been done by the IO, so and so in presence of the then Executive Magistrate of Bilasipara. The whole process of seizing and sealing of the said office building has done by the then Executive Magistrate, and after his transfer, another incumbent Executive Magistrate took over all the charges and duties which is a part of the government service and responsibility. So in presence of them, the Executive Magistrate Bilasipara.
All right, but now what is to be done here? You also won't be able to. address it.
Lordship,
My lord, actually, I am not
What
related
is
to
the
that.
law point here?
My lord, regarding the law, the police have no authority to seize, my lord. Police have authority only
Come
under
prepared,
section
come
102,
prepared.
my lord.
Look up the law, whether the police has the power to seize
My lord,
immovable property.
Supreme Court judgment is there, my lord.
You are ready for final disposal today.
Lord,
Both of you are ready. I'll take it up then, but I'll not adjourn it if I start. It
yes,
will be
sir.
either allowed or dismissed. Ready?
My lord, next Friday, my lord.
Lordship.
Whenever you are ready, but
Yes, sir.
halfway don't say,
Yes, sir.
because the issue here is whether the police has the power to seize
Lordship.
immovable property.
Yes, my lord.
So both of you, are you prepared on that point? No.
My lord, on that point, I have judgment, but other parts, my lord, therefore I want on Friday, my lord, for final disposal, my lord.
Friday, day after tomorrow.
Or next Friday, my lord.
All right.
Let me also look into all this.
The so and so for the petitioner, so and so for the respondents, the core issue involved in the writ petition is as to whether the police could have seized immovable property being the tenanted premise owned by the petitioner in connection with investigation with a police case. Mr. Sharma submits that steps have already been taken. Submits that the premises were stilled in connection with the aforesaid, in connection with which is that case?
PS case number, Lordship.
In connection with
337
PS
of
case number?
2013.
337/2013.
Which PS? Which PS?
Bilasipara.
Vilasipara PS case number so and so in presence of a magistrate.
337 of 2013.
337 of 2000 in presence of an executive magistrate. But after the completion of investigation, application has now been submitted before the magistrate to remove the belongings from the tenanted premises and hand over vacant possession of the premises to the petitioner, to the owner, that is the petitioner. Mr. Sharma, however, prays for 2 weeks' time to obtain updated instruction in the matter. The learned counsel for the petitioner also prays for some time to examine the legal issues and address arguments for this court. In view of the above, let this writ petition be listed for admission again after 2 weeks as a fixed item. Both of you come prepared on that.
Lordship.
This case, Madam Tribunal Autonomous Council has filed a affidavit today. The matter involves my lord. He was selected for a depot, oil depot by the Oil India Limited. And he is a nominated member, and therefore, my lord, this impugn order was passed at 111. The question is whether a nominated member of a Caribbean Autonomous Council is an employee. And for that matter, whether he can be deprived from the already selected depot on behalf of from the IOC. There, that.
So it's a legal question.
That is the only, this is already, the MLA MPs are not, they are not employees. Already decisions are there. He is a nominated member. He cannot be an employee. He had land, he offered the land, he got selected on the basis of the lottery. So now they are.
So he is not drawing any salary.
Now he is not drawing, honorary. Honorary member, he has been nominated by the government.
So he's an honorary member.
Yes, I'm honorary. Now I'm not taking any salary, and I'm a nominated member. So whether in view of this paragraph 15 of 2019-11 SCC, regarding MLA MP. May I just read, madam? Or
Lordship, we are filing our affidavit today, Lordship, and already
they have
served
said
the
I'm
copy.
not an employee. They have said so.
You're supporting this case.
Lordship.
Well,
Lordship,
let the affidavit come, it will be easier.
yes, Lordship.
We'll dispose it of, there is an interim order.
There is an interim order.
How much time you want?
Lordship, we are filing it today. We have already served a copy.
All
Post
right,
the date.
what is your stand? You are the one who's,
The guidelines say that he cannot be employed.
no, he is not an employee.
But the objective of this was so that he can devote his entire time to the retail outlet and not nominate some other managers or someone.
Oh, all your retail outlets, they don't have other business.
We have to go back.
We'll allow the repetition, but let the affidavit come. Sir, Mr. B.D. Das, Learned Senior Counsel, Mr. So Learned Counsel appearing for the repetitioner. Also heard Mrs. Campbell, Learned Standing Counsel. KASU submits that affidavit on behalf of the council will be filed during the course of the day. Considering the nature of controversy involved in this repetition, affidavit of the council would play a vital role in the disposal of the matter. Mr. P. Bharadwaj, Learned Counsel is present on behalf of the IOCL, that is the respondent numbers 1 and 2. In view of the request made by Ms. Campbell, this matter is directed to be posted again after 2 weeks. In the meantime, parties to exchange pleadings will be taken up for disposal.
For the 2 weeks.
Yes,
Can
2
we
weeks.
take up to one?
Obliged.
I think we can get
Interim
a
order
date.
passed earlier to continue.
We can get a date. We can get a date.
In this case, I am appearing for respondent 4 and 5, my lord. I have seen from the records of one IA has been filed, but no copy has been furnished to me, my lord. It has been furnished after 2 weeks, when I will file objection in the meantime, my lord.
I is for interim product, my lord.
You have filed an IA
Yes, sir.
and you are for?
I am for the respondent of 4 and 5. Mainly. Yes. Against,
Serve them a copy.
Lordship, next week.
after
Because
2
they
weeks,
are
my lord, they are outside.
against the stop construction notice of GMC or GMD. They
No
are
construction is going on right now, my lord. Authorities will say, my lord, no construction. They have already stopped it, my lord. Authority has stopped.
No construction is going
It's
on.
not
Heard
all going
Mr.
well.
P. Bhagwal, Learned Counsel for the lead petitioner, also heard Mr. Sheikh, Mr. S. Mukta, Learned Counsel appearing
4
for
and 5.
numbers 4 and 5, who submits that no copy of the IA filed by the petitioner has been served upon him. Therefore, copy be served and he be granted 2 weeks time
My lord.
to obtain instruction and file objection.
Objection.
Mr. Mukhtar has also assured this court that no construction
Yes,
is
yes,
going
my
on
lord.
in respect of the disputed property. Ms. S. Sutia, Learned Counsel is present on behalf of respondent number 1, 2, and 3. In view of the request made by Mr. Mukhtar, copy of the IA be served upon him during the course of the day. Let this matter be listed again after 2 weeks.
Right.
So
as
date
to
may
enable-
kindly be fixed also.
Yes, as a fixed item.
Right.
Earlier order also as a fixed item.
Item 37.
Please, my lord, this case relates to the conversion of the patta, my lord. To that effect, the deputy commissioner of Dibrugarh, my lord. Lordship, kindly have a look at page 21, my lord.
So you are arguing for final disposal today? Ready for final disposal?
Lordship, I'm awaiting my instructions. As per the verbal instruction, Your Lordship, there is no legal provision for the transfer of the T periodic patta to the periodic patta, Your Lordship, as they have.
Transfer or conversion?
A conversion, Your Lordship. Conversion of the T periodic patta to periodic patta. As per the verbal
What do you have to
instructions.
say?
I'm still waiting for documents.
These matters will require
Yes, Your Lordship.
deeper hearing on the
Yes.
basis of affidavit. Heard Mr. J.I. Borbe, Learned Counsel for the petition, also heard Ms. N. Bordole, Learned Standing Counsel, Revenue Department, Assam, who submits that there is no provision in the law for conversion of T periodic patta within course, T periodic
Lordship
patta.
may not record this. I'll furnish the documents.
okay.
Lordship may not
Submit
record
that
this.
instructions as called for are still awaited and therefore 3 weeks further time be granted for obtaining instruction and filing affidavit. Since the prayer is not opposed, same stands allowed. Let this matter be listed again after 4 weeks. In the meantime,
I'll file my affidavit. Your Lordship.
affidavit on behalf of the respondent be filed. You are appearing? Mr. B. Tardal and Civil Council is present on behalf of respondent numbers 2, 3 and 4.
I'm obliged to.
Supplementary list for admission, item 56.
Please, your lordship. Here, my lord, petitioner is a president of the 9 Pukpaka Gaon Panchayat, my lord. Earlier, she had been removed on the ground of no confidence motion against her, and she had challenged before this honorable court, and the honorable court had set aside that order. And pursuant to that, in compliance of this honorable court's order, she was allowed to resume her duty, my lord, her post as president, my lord. That is at page 66, my lord. By official communication dated 66. That is, I am instructed to allow you to continue as president of 9 Pukpaka Gaon Panchayat as per the judgment received by so and so. So accordingly, she has joined her, my lord, post, my lord, and subsequently, my lord, the impugn notice was issued by the secretary, by respondent number 9, my lord. That is at page 67, my lord. 67, my lord. Respectfully, it is stated that today on 2011-2022, 8 members of 9 Pukpaka Gaon Panchayat have sought for a meeting in regard to no confidence motion against you. It is therefore requested that date and time may be fixed for the meeting. Your lordship.
Ms. Chaudhary, this is the synopsis prepared by whom?
Prepared by me.
Can you read it? It doesn't make any sense. Please read it aloud. Let us see what is there in the synopsis. Read it.
This matter relates to impugn notice dated 2011-22 issued by the Vice President, 9 Pukpaka Gaon Panchayat, ward number for convening special meeting.
No. To the petitioner. Read it entirely.
Yes, my lord.
Why are you skipping it?
This matter relates to impugn notice dated 2012-2022 issued by the Vice President, 9 Pukpaka Gaon Panchayat, ward number 2 to the petitioner for convening special meeting on no confidence motion against herself on the charge of misappropriation on the same date of her resuming the charge of president of 9 Pukpaka Gaon Panchayat in terms of official communication dated 2012-2022 issued by the block development officer Bhawanipur Development Block in reference to the official communication dated 19/12/2022 issued by the District Development Commissioner. Moreover, the respondent number 9, Ranjit Pathak, who has issued the impugn, yes, my lord, actually the notice was issued by the respondent number 9, but wrongly it has been typed as the Vice President. Vice President is respondent number 8, my lord. And the impugn notice has
So
been.
you are appearing for whom?
Respondent number 8, lordship, and here the respondent number 8 and 11 are same person, which had been wrongly repeated in the writ petition, lordship.
You filed your affidavit.
Yes, lordship, I have filed my affidavit.
So the matter has to be heard. Where are the records? You have received the
My
records.
lord, I
will
have
be-
filed one additional affidavit. Kindly peruse, my lord, page 91, my lord, all the.
Is it that you want a no confidence motion to be discussed in a meeting?
My lord, they have, my
We
lord,
have
expressed their confidence, my lord.
In my para 5, lordship, I have stated.
I'm not understanding anything.
Your lordship may kindly peruse.
You kindly tell me how much time will you take to write a synopsis, correct synopsis.
My lord, synopsis only the, my lord, respondent number 8.
And otherwise we'll hear it after vacation. Because
my-
your synopsis does not tell what is the case. And then we'll have to go through the entire. report.
Synopsis, my lord, only the respondent number, my lord, 9 has been wrongly
Okay,
typed. as-
you are, I'll pass the judgment.
Yes, my lord. My lord, here, my lord,
Hmm.
after resuming her charge, my lord, the no.
What charge? Who charge? Who?
Charge of president.
Who has
The
determined this charge?
President herself, earlier she had been removed, my lord, and she had approved this honorable court, and this honorable court has set aside the order of removal, my lord. So, my lord, again, she was allowed to resume her charge as president of Gaon Panchayat. So the day when she resumed her charge, a notice has been issued by the secretary that again they have expressed their no confidence. So, my lord, the secretary has no authority because he himself has been transferred and released from this post, and he was posted as tax collector, my lord.
So there is an interim order.
Interim order is there, my lord.
So you are continuing in your. office?
Continuing.
Yes, we'll hear it after vacation. Heard
Yes,
Ms.
my lord.
S.B. Chaudhary, Learned
Interim
Counsel
may
for the,
continue.
lead petitioner, also heard Ms.
M. Das.
M. Das,
Das.
Learned Counsel appearing for the respondent number 8. You have filed your affidavit.
Lordship, I have
Who
filed.
submits that affidavit on behalf of our client is already on record. You have also filed pleadings.
No, Lordship, we have not received the record.
Ms. N. Bora, Learned Standing Council, PNID Assam, however, submits that records are yet to be received and therefore some more time is granted for obtaining instruction. In view of the above, let this matter be listed again after the upcoming Puja holidays. Interim order passed earlier to continue.
Yes. 38 for order, 38 and 39.
Yes.
Lordship, I am the respond number 8 in item number 38. And Lordship, I am the petitioner in the item number 39, Lordship.
What are these matters?
Lordship, this is relating to initiation of no confidence motion against the president. Lordship, in item number 69, the grievance of the petitioner is against the order passed by the respondent number
Well,
3.
they are absent. We'll pass it over for a week. The petitioners counsel are absent when this matter was called up before this court. It appears that the petitioners were absent even before the Lojima court when the order dated 17/6/2022 was passed. Be that as it may, since no, before that, right, Mr.
M.R. Sharma for
M.R.
respondent
Sharma,
number 8.
Learned Counsel is present on behalf of respondent number
8. Lordship,
8 and Miss
in item number 38.
8 in item 38 and Miss
This was on behalf of Standing Council.
and first of all, Mr. N.K. Debnath, Learned Standing Council PNID Assam is also present. However, since the petitioners counsel are absent today, for ends of justice, these matters are adjourned for 2 weeks so as to give them one last opportunity to appear.
Lordship,
this case.
I am for the petitioner in item number 39, and in that matter, Lordship, there is an interim order in this matter. Which may
Then
kindly
this order you will pass in item 38, huh? This one. And then you write,
item 39.
Mr. Sharma, Learned Counsel is present on behalf of the item, on behalf of the petitioners. Learned Standing Council PNID Assam are also present. However, the council representing the private respondents are absent today. In view of the above, let this matter be listed again along with item 38 after 2 weeks. Interim order passed earlier to continue.
Much obliged, Your Honor.
Item 40.
As per order dated 31/8/2023, Lordship.
Lordship, we have received the instructions. I am praying for 4 weeks to file our affidavit.
Mr. S. J. Sharma, Learned Counsel is present on behalf of the petitioner. Mr. H. Sharma, Learned Additional Senior Government Advocate Assam, appearing for the respond numbers 3 and 4, submits that instructions have been received and therefore 4 weeks time be granted for affidavit, for filing affidavit. The prayer is not opposed by the petitioner's counsel. Ms. G. Hazarika, Learned SC Revenue and Disaster Department is present on behalf of respond number 1. And anybody for respond number 2? And Miss
RM Borla.
RM Borla, Learned Counsel is present under the Finance Department. On the request of Learned Additional Senior Government Advocate Assam, this matter stands adjourned for 4 weeks.
Obliged.
Item 41.
Please, Lordship. In this case, in regard to this matter, since respondent number 1 to 5 is service is complete, my lord, and the respondent number 6 and 7, my lord, register post and as usual process was step was taken by lord, but
as far as Lodging code, service is not completed. So my lord, my humble submission, my lord, I will take Dosti service regarding 6 and 7. And regarding 8, 9 and 10, notice was not issued, my lord. So kindly we notice. In pursuance of respondent number 8, 9 and 10.
Notice has to go by registered post also. All right.
Yes.
1 to 5, and who is for 6 and 7? What about respondent 6 and 7?
6 and 7.
Not completed, lordship.
6 and
Notice
7,
could
my
not be
lord,
completed.
notice not completed.
Then you have to
My lord,
take.
I will take Dosti service, my lord. Already registered post and as usual service, I have.
Dusty service is alternative. And in addition, you have to take registered and then dusty. All right. Heard Mr.
M.A. Chaudhary.
M.A. Chaudhary, and counsel for the petitioner. Also heard Ms. S. Kabrai, learned standing counsel KAC appearing for the respond numbers 2 to 5. Mr. H. Mr. G. Ms. G. Hazarika, learned SC Revenue Department is present on behalf of the respond number 1. On the request of Mr. It appears that notice was not issued earlier to the respond numbers 8 and 9.
8, 9 and 10.
8, 9 and 10. As such, let notice be issued on respond numbers 8, 9 and 10 by registered post with AD. 8, 9 and 10 returnable in 4 weeks. Steps by registered post with AD. Within a week from today. Petitioners counsel to also take fresh steps by registered post with AD for service of notice upon respond numbers 6 and 7. In addition, dusty notice routed to the registry of this court is also permitted upon respond numbers 6 to 10. Steps be taken accordingly.
Item 42.
42 also, lordship, we have received the instruction. I am praying for 4 weeks time, lordship, to file affidavit.
Mr. B. Sinha, learned counsel for the petitioner, is present on the request of Mr. H. Sharma, learned additional senior government advocate Assam, appearing for the official respondent. 4 weeks further time is granted for filing affidavit. List accordingly.
Item 43.
May I please, your lordship? Your lordship, order dated 25/8/23 was pleased to grant me interim protection. Page 22, your lordship. Having regard to this second circumstance of the case, it is hereby provided that the petitioner shall not be evicted from the land in question until the next day fixed. Let the matter be listed again on 15/9/2023. Now, your lordship, being the interim order was while in force on 31/8/2023. The lordship, I make a statement in paragraph 5, page 9. They cut down valuable trees and also demolishes some structure, your lordship.
Sorry?
Demolishes some tree, cut down some trees, your lordship. On 31/8/2023, the respondent number 2, along with the help of the
25/8/2023, NOM 8 weeks. Notice 8 weeks. Only one.
Notice, your lordship.
Notice, yes. 8 weeks.
May I please, your lordship?
My lordship, order will be there.
My lordship, I filed read petition as well as content petition, my lordship. It has been already 8 months, my lordship. Honorable High Court directed, reinstated me in my post of president, my lordship, of Patagari Gaon Panchayat. But till date, I have not given the charge, my lordship. And moreover, my lordship, the Honorable High Court directed for convening a fresh meeting, my lord. That was also not done, my lordship.
Which is the order?
Page 12, my lordship. Page 12, operative portion, my lordship.
Operative portion is at page 17, my lord, last para.
Last period. Till date, Vice President is discharging the charge, my lordship.
Where is the direction to reinstate you?
My lord, this is the,
There's no such direction in the.
so I was, till date, no meeting has been held, my lordship, and no meeting has been convened, my lordship. The vice president is discharging, my lordship. Impugned resolution is interfered with and set aside. When
Please
it has been,
answer my question.
Yes,
Is there any direction to reinstate you?
no, my lordship, impugned, no confidence resolution was set aside. So by virtue of this order, my lordship, I have been, it is presumed that I have been reinstated, my lordship.
Presumptions cannot be enforced in contempt case. Yes, why the meeting was not held?
My lord, the day the meeting was supposed to be held, that is 17th of January, as per the order, he wrote a letter to the BDO stating that kindly stall this meeting on the ground that 2 ward members have more than 3 children, so they ought to be disqualified. His letter has been annexed in the affidavit given by the DC.
In the contempt matter, all the papers have been annexed, but if I may most humbly draw your lordship's attention to the counter affidavit filed in the contempt application, my lord. Annexure 7, page 35. There, the second matter.
And what is the writ petition about?
Well, he is praying for reinstatement, as this honorable court has. He is praying for reinstatement of the writ petition. Lordship comes to page 17 of the writ petition. No, my lord, that's the order. My lord, his petition before the deputy commissioner. Page 25, my lord.
So this is ready as regards service, the writ petition?
Yes, my lord, we've filed an affidavit also, my lord, countering, he says.
All right, we'll have it for admission then.
My lordship.
Yes,
No,
after
really.
2 weeks, yes. But Mr. SB School and Council for the writ petition submits that the matter is ready as regards service and therefore can be taken up for admission. Ms. S. Sharma, learned G. Assam, and Mr. P. Hendrick, learned SC PNRD are also present on behalf of the official respondent. In view of the above, registry to list this case for admission along with contempt case number 83 of 2023 after 2 weeks as a fifth item.
My lord, it's hot date, my lordship. My
Next
lord.
matter, please.
So for service report is concerned, my lord, it's completed.
Service is completed. Matter will be listed for admission. Or Mr. M. Mondal and counsel for the petitioner who submits that this matter is ready as regards service. Office to verify and list the case for admission here.
Emergency is there.
For
admission hearing.
Lordship, I am appearing for item 46. Item 46.
47, you will mark out present. This N. Boral and the SCPNRD department is present. In item 46, you are appearing.
Lordship.
May I please, your lordship? This IA has been filed for deletion of the name of NHI Dishal, my lord.
Deletion of name
I
of,
am for a petition.
NHI Dishal, lordship.
you have objection.
No, that can
Because-
be done at his own risk.
No, you, if you agree, then you will have to bear the brunt. Not your risk, not his risk.
He sought for striking out his name from respondent number 2. He said that he has no involvement in the present case.
I have.
You agree to that?
Yes.
All right, then we'll allow it. Mr. R.K. Talura, learned counsel for the applicant, also heard Ms. R. Devi and B. Devi, learned counsel appearing for the OP writ petitioner. This IA has been filed by the NHI DCL,
My lord.
Managing Director.
Managing Director of National Highways Infrastructure and Development Corporation Limited, bracket NHI DCL, with a prayer to strike out the name of the respondent number 2 from the array of parties in the connected writ petition. By referring to the statements made in the IA, Mr. Talukdar submits that his client has no involvement in
Yes,
the matter
paragraph 4 of
and
IA.
has been wrongly impleaded in the writ petition. Ms. B. Devi, learned counsel for the writ petitioner opposite party, submits that she would have no objection if the prayer is allowed. The learned departmental counsel appearing for the respondent numbers 3 and 4, namely Miss R. Bora and Miss K. 1, 3 and 4, namely Miss K. Phukan, learned CGC, comma, Miss R. Bora, learned SC, NHAI, and Mr. C. Sharma, learned SC, Land Revenue Department, SC, NC Hills Autonomous Council are present and do not have any objection if the prayer made by the applicant is allowed. In view of the above, it is hereby ordered that the name of the respondent number 2 be deleted from the array of parties in the connected writ petition, being WPC number 3022 of 2023. Amended cost title of the writ petition be filed by the writ petitioner within 10 days from today. The matter will be listed thereafter. Now you have to file an amended cost title.
Yes, my lord, regarding respondent number 3, my lord, file affidavit in opposition, I may be allowed 1 week time or 10 days time.
Yes.
To
In the
file
meantime, parties
reason.
may exchange pleadings in the main writ petition as well. Yes.
Item 48.
Also, we have filed the
Highest is disposed of. Highest is disposed of. Yes.
Also, we have filed an stay vacating application.
I may be allowed, my lord, 3 weeks time lawsuit to object lawsuit.
3 weeks. Which order you want to vacate it?
Lordship order dated 3/2/2023.
Page number
Lordship 15.
15.
1/5. The
Two weeks time you will get lost. But Miss S.
G. Swami.
G. Swami, learned counsel for the applicant. This IA has been filed with a prayer to vacate the interim order dated 03/02/2023, passed by the learned single judge in WPC number 598 public 2023. Mr. M.H. Ahmed, learned counsel for the writ petitioner OP, prays for and is granted 2 weeks time to file objection. Let the matter be listed again after 3 weeks as a fixed item. Interim order passed earlier to continue till then.
Item 50.
As part of office note data 7/9/2023, the service report to respondent number 3 and 4 has been completed. We have taken a step both in the usual process and the rest of post.
You are for respondent numbers?
2 and 5.
2 and 5.
And who is for one?
One is for the central government, Mr. Architect
Thirty was
Chaudhary
appeared.
appeared last time.
Heard Mr.
H. Shetty.
Shetty, learned counsel for the writ petitioner Perus. Perus, the office note dated 7/9/2023, which goes to show that service report on respondent numbers 3 and 4 is still awaited. Mr. Ms. A. Gayan, any CGC present here? Any CGC? None has appeared for the respondent number 1. Mr. A. Chandran, learned senior government advocate, State of Arunachal Pradesh, is present on behalf of respondent numbers 2 and 5. Awaiting service report on respondent numbers 3 and 4. This matter stands adjourned for 4 weeks.
In this item number 51, 52, 54, 55, same also.
Same order.
Same order.
Same office note.
So, no, office note in item 52 is 8/9 and 54 is 8/9 only.
3 and 4 only. Respondent numbers 3
3
and
and 4 only.
office note same order.
Office
Up to
note in
55.
item 52, 8/9. At least.
Much obliged.
Supplementary list for order, item 57.
May I please, your lordship? Lordship will first like to seek apology that we had to file this IA for recalling of the order as we are not present on that day.
Yes.
Now, my lord, we'd like to go to the merits of this case now.
Well, this is an interesting case on the matter of eviction to my mind. Because first of all, my lord, these are the petitioners who hold voter ID card on the place where they are seek to be evicted. Secondly, they also have Pradhan Mantri Awas Yojana houses over the land which they are seeking to be evicted. Now, my Pradhan Mantri Awas Yojana houses are constructed there through bona fide, through all bona fides, because it is because in their affidavit also they've admitted that there are Pradhan Mantri Awas Yojana houses. Therefore, my lord, they this raises a question. This case actually raises a question of both.
No, what is it? You are occupying some land
They're occupying some land in Hojua Pathar, Narkotia, my lords.
where your residential houses are built.
Yes, my lords.
These houses are built under Pradhan Mantri Awas.
There are few petitioners whose my lord, what happens at Pradhan Mantri Awas, there are few petitioners over they have Pradhan Mantri Awas Yojana houses. However, my lord, the other petitioner could not get the Pradhan Mantri Awas Yojana houses because they come through the priority list, that is through the social economic caste census, my lords. And they are awaiting Pradhan Mantri Awas Yojana houses, being the fact. Now, my lord, these Pradhan Mantri Awas Yojana houses are being given only once in a lifetime. So, my lord, if they are evicted, then therefore, my lord, the question would arise that whether the Pradhan Mantri Awas Yojana houses will be given again or not. Because if they are evicted without giving any notice, and therefore the bigger question of law arises, because the Pradhan Mantri Awas Yojana, what happens, my lord, they invest money from their own pocket, then the people that check the report, and thereafter they sanction the money accordingly. So it is the first investment of the person first, and then the government sanctions money. Now, therefore, my lord, if we see the section 18 clause 2, which talks about, which brings to impediment for the government to evict any land is the property use and the bona fide user. Therefore, my lord, if a person has a Pradhan Mantri Awas Yojana house over the land, I put this question to myself, whether a person would not become a bona fide user or not. In my humble submission, a person would become a bona fide user. Now, my lord, it is also interesting question. If I may take to their affidavit, my lord, I want to take my lord to their affidavit. That is on.
First of all, where is your explanation for being absent?
My lord, we have put it in the interlocutory application, my lord. Actually, what in interlocutory application we have put it, my lord.
Yes, you were absent on the last day.
Yeah, yes, my lord. Actually,
where is the explanation for that?
We have written that due to unavoidable circumstances. Actually, what has happened, my lord, that there is also case regarding the Naharkotia only that we had to file in the Chief Justice Court, and we could not arrive on time because on the next day there was a Vishwakarma Puja, and the cab that we had to travel cancelled on the last minute, and therefore we could not travel on time, my lords. This is a bona fide mistake, my lord, and we'll have never repeat it again, my lord.
It is that case, my lord, where lordship has, my lord, was pleased not to.
No, what you want to evict them?
Evict, my lord, evict, my lord.
What about this? Their claim that they have constructed Prime Minister.
In our affidavit, we have given all the materials, my lord. They have been allotted alternative plot of land.
We'll hear it next week as a fixed. Till then, we maintain status quo, Mr.
Again, my lord,
interim may be extended, my lord.
Interim, my lord,
you maintain status quo till the next week.
That construction of setting work order, everything has been
Mr. P.
issued.
Buragoyan and a
Everything has been issued, my lord. Work order has been issued.
No, it may be cancelled also. If we find that the eviction process is not correct, then the work order may completely be cancelled.
Lordship may kindly then.
We would like to know what is the nature of their occupancy of the land. If the occupancy is legitimate, you have to cancel your work order. That's the outcome.
No, occupancy is not legitimate. They were enclosures, my lord, in government land. Perhaps, my lord, they have my lord, build their houses, my lord, Pradhan Mantri, that by ipso facto will not give them any right, my lord. Law is well settled, my lord. And they have
you have paid them money under the PMG. Or
yes, everything is there, my lord.
These are questions we cannot throw it out just like this. How Mr. P. Buragoyan
kindly then
appearing for the
post the matter, my lord, in all respect, my lord, on coming things there, my lord. Because we are in an urgent state, my lord. Construction of mini stadium is being halted, my lord. Kindly see, my lord.
But my lord, people will also, my lord, but people will also not have a roof to sleep under, my lord. They are all BPL.
We'll see. What if the law you don't have any right, then you don't have any roof.
My lord, we'll submit to that. We'll submit to that.
Only thing is, we don't want to do it in a hurry. Let him find this.
Yes.
But it was absolutely unacceptable.
Yes, my lord. We'll not never was a mistake, my lord.
We'll see whether that can be accepted ultimately on Thursday when you hear the matter. We'll examine that aspect of the case. Mr. P. Burman and counsel for for the applicant to read petitioner. Also heard Mr. R.C. Borpujari, learned standing counsel, Revenue Department, Assam, appearing for the state. Full stop. This IA has been filed by the read petitioners in the connected proceeding with a prayer to extend the recall oblique modify the order dated 18/9/2023 passed in WPC number 3901 of 2023. Where is that order? 18/9.
Annexure 2.
By the order dated 18/9/2023, this court had declined to extend the validity of the interim order dated 36/2023 on the ground that the counsel for the writ petitioner was absent, and therefore the petitioners have failed to show any reason for extending the interim order. By filing this IA, the writ petitioners as applicant have approached this court explaining the reason for previous non-appearance by contending that if the applicants are evicted during the pendency of the writ petition, then not only would the petition become infructuous, but the same would also lead to irreparable loss and injury to the writ petitioners. Mr. Borpujari, on the other hand, submits that the writ petitioners are encroachers upon government land, and the operation of the interim order is delaying the construction work of Naharkotia, a stadium, which has been undertaken by the authorities. Having heard submissions of both the sides, this court is of the opinion that the writ petition itself would call for expeditious disposal. As such, the writ petition is directed to be listed on 3rd October 2023 as a fixed item for final disposal. Parties to come prepared accordingly. Status quo be maintained with regard to the possession of the petitioners till the next day. IS tells disposal. We'll dispose it on that day, and whatever be the ground, there will be no adjournment.
My lord, with all respect, my lord, can it be on 28th of September, my lord, if it is possible?
No. Why? What is the difference between 3rd October?
3rd October, my lord, I am led by my lord the Advocate General here. My lord, on 3rd October, my lord, possibly, my lord, we may not be here.
Then we'll do it on 5th October.
5th, my lord, from 3rd onwards, my lord, for some time, my lord, with all respect.
Then you seek adjournment. 28 is not convenient for this court.
My lord, then